Good afternoon. My name is Rick Hassan of the UCI Irvine School of Law, and I want to welcome you to the 5th Annual Supreme Court Term in Review event. This event brings together the law school, the university, and the larger legal and broader Orange County community to talk about one of the country's most important and influential institutions, the Supreme Court, with an outstanding group of scholars, lawyers, and journalists. I want to thank the UCI Law staff for the support they've given to this event, especially our events coordinator, Cassandra Flores, and our communication staff, Colleen Tarakani, Iris Yokoi, and Riza Barnes. I also want to thank the law school's dean, Erwin Chemerinsky, for supporting this event in its 5 years, which has grown from an event with fewer than 100 people in one of our smaller classrooms to today's very large crowd. Each term of the Supreme Court, beginning the first Monday in October, is different, with some terms more important than others. During our first annual Supreme Court event in the summer of 2011, one of our initial panelists, Slate's Dahlia Lithwick, remarked on the dullness of the October 2010 term. The next year brought us the healthcare case. 2012 brought us a term that Dean Chemerinsky called amazing, which included rulings on same-sex marriage. The 2013 term was somewhere between dull and amazing. But nothing in the 5 years matches this term, which included major rulings on same-sex marriage, the Affordable Care Act, lethal injection, housing discrimination, and much more. It was a blockbuster term, one which featured some surprising wins for the liberal side of the court, although the extent to which the court has moved left is very much up to debate. Next year's term promises cases on affirmative action, the power of public sector labor unions, and likely major cases on abortion and the one-person, one-vote rule. We're probably unlikely to continue to call the court liberal in the next term. It's hard to imagine a more distinguished and qualified panel to help us sort out what has just passed and what is to come. We have a packed schedule, and so I'll give only a brief introduction of each of our 5 panelists. Their full biographies appear in the program. Erwin Chemerinsky is the founding dean and distinguished professor of law and Raymond Pryke Professor of First Amendment Law at UC Irvine School of Law with a joint appointment in political science. Prior to assuming this position in 2008, he was the Alston Bird Professor of Law and Political Science at Duke University. Prior to that, he was a professor at the University of Southern California Gould School of Law from 1983 to 2004, including as the Sidney M. Ermis Professor of Public Interest Law, Legal Ethics, and Political Science. He's the author of 8 books, including The Case Against the Supreme Court, and more than 200 law review articles. He frequently argues appellate cases, including in the Supreme Court. In January 2014, national jurists named Chemerinsky the most influential person in legal education in the United States. Linda Greenhouse is the Knight Distinguished Journalist in Residence and Joseph Goldstein Lecturer in Law at Yale Law School. She covered the Supreme Court for the New York Times between 1978 and 2008 and writes a bi-weekly column on law. Ms. Greenhouse received several major journalism awards during her 40-year career at the time, including the Pulitzer Prize and the Goldsmith Career Award for Excellence in Journalism from Harvard's Kennedy School. In 2002, the American Political Science Association gave her its Carrie McWilliams Award for a major journalistic contribution to our understanding of politics. Her biography of Justice Harry A. Blackmun, Becoming Justice Blackmun, was published in 2005. Her latest book, Before Roe v. Wade, Voices That Shaped the Abortion Debate Before the Supreme Court's Ruling, with Reva Siegel, was published in 2010. Canon Shanmugam heads William & Connolly's Supreme Court and appellate litigation practice. In naming Mr. Shanmugam in 2015 one of the 500 leading lawyers in America, Law Dragon magazine described him as inspiring and in demand. He has argued 17 cases before the Supreme Court, including 3 cases in the 2014-15 term. Last year, he broke Edward Bennett's Williams record for the most Supreme Court arguments by a lawyer in the firm's history. Mr. Shanmugam has been recognized by numerous publications as one of the nation's leading Supreme Court and appellate advocates. In a recent National Law Journal article, praised him for his confident manner and eloquent elocution before the court, stating that he never seems to get flustered. See how that goes today. After law school, he clerked for Supreme Court Justice Antonin Scalia and for Judge Michael Luttig on the U.S. Court of Appeals for the Fourth Circuit. The Honorable Jeffrey Sutton is a judge for the United States Court of Appeals for the Sixth Circuit. Prior to this, he was a partner with the law firm of Jones Day, Rivas & Pogue, Columbus, Ohio branch since 1996. Before that, he was an associate with the firm where he specialized in commercial litigation, constitutional litigation, and appellate practice. Since 1993, Judge Sutton has been an adjunct professor of law at the Ohio State University College of Law, teaching seminars on the United States Constitution and state constitutional law. From Richardson is a professor at UCI Law School. Her interdisciplinary research uses lessons from cognitive and social psychology to study criminal procedure, criminal law, and policing. Currently, she is working on a book that examines the legal and moral implications of the mind sciences research on policing and criminal procedure. Her article, Police Efficiency and the Fourth Amendment, was selected as a must-read by the National Association of Criminal Defense Attorneys. Her co-edited book, The Future of Criminal Justice in America, was published by Cambridge University Press in 2014. Professor Richardson's legal career has included a partnership at a boutique law firm and work as a state and federal public defender in Seattle, Washington. She was also an assistant counsel at the NAACP Legal Defense and Education Fund. Professor Richardson is the 2011 recipient of the American Association of Law Schools Derek Bell Award, which recognizes junior faculty members' extraordinary contributions to legal education through mentoring, teaching, and scholarship. That was the brief introduction of our panelists. To keep the program moving, I've asked each panelist to speak for no more than 8 minutes on one of the court's cases in the court's term. That will leave us with about half of the time for panelists to engage with one another and to take questions from you. We will also be taking questions via Twitter using the hashtag UCILawSCOTUS. At question time, I have 2 requirements. First, the question must be brief, and second, it must be a question. There will be absolutely no argle-bargle or jiggery-pokery. I'll be ruthless in cutting people off to keep things moving. We're going to start with Professor Richardson and work our way down, and let's save our applause until the end of the program. Thank you very much.
Thank you, Rick, for inviting me to be a part of this incredible panel, and thanks to all of you. It's my pleasure to be here for the first time. This is my first year at UCI, and so I'm thrilled to be addressing all of you. And I just want to say, because Rick didn't mention it, he said when you ask your question, make sure it's a question, but he didn't say that you couldn't use the term gobbledygook, which is another famous Scalia-ism, and I'll talk more about that in a second. So it's probably not much of a surprise, given my background, that I chose today to discuss the Supreme Court's death penalty case, known as Glossip versus Gross. And I'm a bit anxious about talking about the case, and here's why. Whenever people talk about the death penalty, emotions run high, right? I'm sure you've all heard that you shouldn't talk about the death penalty or religion or politics in front of a general audience. Well, with the death penalty, I once did not follow that advice at a dinner party I was holding. And unfortunately, one of my guests ended up accusing another of being morally bankrupt. So hopefully that won't happen to me today. So let me share a little bit of background on this case. So for most states that have the death penalty, they utilize a 3-drug lethal injection cocktail to carry it out. So this case raises a challenge to the first and arguably most important of those drugs. And that's because the reason I say most important is that first drug is an anesthetic. And so what it's meant to do is to render the inmate unconscious so that he or she won't feel the agonizing pain that's associated with the second and third drugs. Pain that Justice Sotomayor described as being the chemical equivalent of being burned at the stake. So the problem in this case arose in around 2014 when states could no longer gain access to reliable anesthetics. And by reliable, I mean anesthetics that could render an inmate unconscious and keep him or her unconscious when the painful drugs were administered. And part of the reason that states could no longer gain access to these anesthetics is the result of successful advocacy by death penalty opponents. And their tactic was, or their thought was, if we could dry up the supply of reliable anesthetics, states may no longer carry out the death penalty. At least that was the thought process. Unfortunately, that tactic may have backfired because states began to rely on a sedative known as midazolam, to take the place of the anesthetic. And the problem is that the FDA has not approved this sedative for use as the sole anesthetic during surgery because it's unreliable. It doesn't keep people reliably unconscious. States began to rely on this sedative, and a series of botched executions began. One of those took place in Oklahoma. It was the execution of Clayton Lockett. He was injected with midazolam. He was declared unconscious. But when the next two drugs were administered, he woke up. He began to struggle against his restraints. And observers heard him say, "The drugs aren't working. Something's wrong." There was another execution in Arizona where the inmate struggled to die for 2 hours, gasping for breath and struggling against his restraints. So as a result of the botched execution in Oklahoma, inmates on Oklahoma's death row filed a federal lawsuit claiming that the use of midazolam violated the Eighth Amendment's prohibition against cruel and unusual punishments because the use created a substantial risk of severe pain. Both the Federal District Court and the 10th Circuit Court of Appeals ruled against the inmates, and then the Supreme Court granted cert. And I just want to share a couple of highlights from the oral arguments, which were particularly testy. None of the justices, let me just say this, none of the justices explicitly referred to the other as being morally bankrupt. That did not happen. However, so with the more liberal members of the court, they expressed deep frustration with the use of midazolam, arguing that use of this sedative was the equivalent of human experimentation. Justice Kagan was becoming extremely frustrated with the Solicitor General of Oklahoma when she kept questioning him about what the court should do in the face of the information deficit about how reliable the drug was. And finally, she became so frustrated that she says to the Solicitor General of Oklahoma, and I quote, "Suppose that we said, we're going to burn you at the stake," end quote. And her point was, what if we were going to burn you and we were going to use a sedative like this? So maybe you'll feel pain, maybe you won't. What would you say then? She says to him. The more conservative members of the court also expressed irritation, so Justice Alito accused death penalty advocates of quote unquote guerrilla tactics, and saying that it was those guerrilla tactics that resulted in the state's inability to gain access to reliable anesthetics. And both Justices Scalia and Kennedy asked the inmate's attorney, should we hold those tactics against your clients here? Ultimately, the more conservative members of the court prevailed in a 5-4 decision written by Justice Alito, but signed on to by the Chief Justice and Justices Kennedy, Scalia, and Thomas, and they ruled against the inmates on 2 grounds. First, they affirmed the lower court's finding that midazolam did not pose a substantial risk of pain. And secondly, and more importantly, for future claims that raise challenges to the mode of execution, the court said, in the future, inmates who want to challenge the mode of execution, they have to also demonstrate that there's another alternative method available to kill them. Justice Sotomayor wrote a dissent. It was an angry dissent. She disagreed with both points. As to the first point, she said, listen, court, you have abdicated your responsibility to carefully review the lower court's findings here, especially because the state's expert below based his opinion largely on the website drugs.com. I'm going to skip over the Sotomayor's response to the second argument because I only have 1 minute left. And so I just want to say that the most intriguing opinion to me was written by Justice Breyer, signed on to by Justice Ginsburg. It was a dissenting opinion where he essentially says, or he did say, after my 20 years on the bench, I believe it is highly likely that the death penalty violates the Eighth Amendment. So I am sure I am out of time now. I'm sure others will talk about the theme of the Supreme Court, so I will pass this along, but I look forward to interacting with you during the Q&A. Thank you.
Thank you, Rick and Erwin, for inviting me out to sunny Southern California from being from Columbus, Ohio. That's a great invitation. But thank you above all for giving me the liberty of talking about a case in which my position was affirmed. I had a couple not go so well this term, so I'm incredibly grateful for that as well. My description of the case will be, I think, fairly brief, and I may be able to offer a few general thoughts about the term during my presentation. If not, I'll do that later. My case is Elanis versus the United States. Very interesting fact pattern. There's a statute, 18 U.S.C. 875C, which prohibits threats to injure another delivered in interstate commerce. That would cover the internet. So the question is, what is a threat when delivered, in this case, through Facebook, delivered to a former wife, coworkers, and bosses? Anthony Elanis was an interesting fellow, had some things not go so well for him, both at work and with his marriage. And as those things fell apart, he converted himself into something of a rap artist. I suspect that's not helping him on the employment front just yet. But to give you a flavor for his postings, here's one. So some were directed to his coworkers, some to bosses, some to his ex-wife. Here's just one. This is the one I can read and still have it go on PBS without substituting words. So on Facebook and directed to his wife, fold up your protection from abuse order and put it in your pocket. I'm not doing this in the rap. I really actually... I actually haven't heard him perform this, so I wouldn't even be able to do it if I could. But it's a form of poetry. Is it thick enough to stop a bullet? Try to enforce an order that was improperly granted in the first place. Methinks the judge needs an education on true threat jurisprudence. And prison time will add zeros to my settlement. And if worse comes to worse, I've got enough explosives to take care of the state police and the sheriff's department. So these posts got the attention of the police, they obviously got the attention of the ex-wife, the co-workers, and the question was whether they're prescribed threats under federal law. That's a little trickier than you might think, and some of the threats were even more serious than that. The court for a while has said these threats have got to be true, real threats, not sarcasm and the like. And that's because of the First Amendment principles lurking in the background. You don't want to construe a statute in a way that violates the First Amendment. Elanis' key defense at trial was, hey, listen, Eminem does this kind of thing all the time. If Eminem can do it, I can do it. Put to the side the quality of the lyrics and other things along those lines. So his main argument in the Third Circuit, which is where the case came from in Philadelphia, was that the First Amendment protects my right to engage in this kind of rap artistry, even if it does contain these pretty negative graphic language directed at other people. That's a surprisingly complicated issue. 9 circuits around the country had said there's not really a First Amendment problem here, and it allowed for a certain type of jury instruction, which I'll get to in a second. 2 others had said there was a First Amendment problem that had to be accounted for in terms of how the jury was instructed as to whether something was a threat or not. The Supreme Court took the case from the Third Circuit, and in what I would consider a pretty classic move for the Roberts Court, which has now been with us for 10 years, they added a question presented, and because again, he had raised a First Amendment argument, and the question presented was whether, as a matter of statutory interpretation, how to read the word threat in the federal statute. Perhaps the court could resolve the case by simply looking at what the word threat meant as a matter of English and background principles of criminal law. So as the case gets to the court, it's got the First Amendment issue and it's got the statutory interpretation issue. Everyone's focused on the First Amendment issue, perhaps no surprise, and people very focused on it given that the internet is so prolific. I'm in my 50s, I've got young kids. I'm still trying to figure this thing out. The one thing I am realizing from watching the behavior of my children is the internet has really changed the way people communicate, and if you ask me, really changed the nature of what privacy is. I see my kids telling the world every day exactly what they're doing and why. As far as I can tell, for their generation, privacy is another word for loneliness. They don't want anything to do with it. They want to let everybody know at all times what they're doing, and this is how their preferred means of communication. Well, if it's your preferred means of communication, that means there's going to be a lot of things going out there, many of them not thought through, and many of them poorly worded, and many of them potentially threatened. Not many, but some potentially threatening. Chief Justice Roberts writes the opinion for the court, and in what I consider a classic move by him and his court, he avoids the constitutional question by construing the word threat to require some awareness of wrongdoing by the defendant. Here, Mr. Orlanis, or Tone Doogie, his pseudonym on the internet, as a rap artist again. And that required a reversal of the lower court decision, because what the lower courts had said was that something is a criminal threat if a reasonable person would perceive it as a threat to injure. And if you know anything about law, that's a negligence standard. That doesn't require any consciousness of wrongdoing. And that's highly unusual in the criminal law. Most criminal law cases, most people convicted of crimes, have some awareness of the wrongdoing and of why what they're doing is something they're not allowed to do. And we don't usually put people in jail because of mistakes. And mistakes is really another word for doing something that has a reaction that a reasonable person would have appreciated, but in this particular case, they didn't. So that comes out really 8-1 at the court with Roberts writing. The question then is, okay, if the standard is not negligence, how a reasonable person would react to the words, what is the standard? And that divided the court. The question was whether to recklessness, something as modest as recklessness, would suffice for a violation, or whether it had to be knowing or more intentional. And again, I would call it a classic move of the Roberts court. They ducked that issue and said it's enough to say that this instruction was a negligence instruction. That doesn't suffice. That led Justice Alito to drop out of the majority, because Justice Alito thought you could very well resolve the case on recklessness grounds and decide that any error was harmless. So it ultimately is really a 7-2 case. It'll be interesting to see what happens at the lower courts. My court, in fact, has already had one case trying to figure out whether recklessness suffices. It's a very interesting statutory interpretation case. The statute comes from the 1930s, and the concept of recklessness in the criminal law comes after the 1930s. That's introduced through the Model Penal Code. So it's a little strange to think, as a matter of statutory interpretation, that Congress meant to include a concept that had not yet appeared in the law. On the other hand, the majority opinion does suggest that as long as you're above negligence, other state of mind, mens rea requirements will probably work, and that would seem to include recklessness. So it's going to be really interesting to see what they do with that, but I can promise you there are going to be more and more of these cases because of Facebook and the internet, and this is the way we communicate. And I'm going to guess it's a little easier to make threats anonymously through the internet than it is face-to-face, so I suspect there'll be more of them, and perhaps more, I suspect a lot more charges as well. So thank you.
Great. Well, good afternoon. It's great to be here in the home of the Anteaters, and like Judge Sutton, as a native of the East Coast, I'm awfully happy to be in Southern California at this time of year. And thank you to Dean Chemerinsky and to the UCI Law School for inviting me. The law school is such a tremendous success story, and it's great to be here. I really wanted to talk today about one of the cases that I argued last term on the question of whether a dismissal that is still pending on appeal counts as a strike for purposes of the 3 strikes provision of the Prison Litigation Reform Act.
Oh, go ahead.
But Rick told me that I had to talk about same-sex marriage instead. So I'm going to talk about this little case that you may have heard about by the name of Obergefell versus Hodges, which is, of course, the landmark decision from the Supreme Court this term on same-sex marriage, and I suspect that you probably already know a little bit about the case, so I'm not going to spend a lot of time setting out the background. These are really 4 consolidated cases, all of which came from the Sixth Circuit, and indeed Judge Sutton wrote the decision that essentially triggered Supreme Court review. And these are, of course, various couples as plaintiffs seeking the right to either enter into same-sex marriages or to have their same-sex marriages recognized as a matter of state law. The Supreme Court, in the Windsor case to which Rick alluded, had held a few terms ago that the federal law defining marriage in the traditional fashion as marriage between one man and one woman was unlawful. In doing so, it relied in part on principles of federalism, but in part on constitutional principles. And that decision really sort of teed up squarely the question of whether there is an underlying constitutional right to same-sex marriage. Most of the lower courts to have considered the issue before Judge Sutton's court considered it had held that there was in fact such a right, relying on sort of a reading of the entrails of the Supreme Court's decision in Windsor, and ironically enough, often relying on Justice Scalia's dissent, which had said this is essentially but a short step away from recognizing such a fundamental right. But the Sixth Circuit reached a contrary conclusion in the opinion of Judge Sutton, and I suspect he may have one or two things to say about this later on in the program. The Sixth Circuit essentially said that this was a matter that was controlled by an earlier Supreme Court decision, a decision in a case called Baker versus Nelson, a summary decision that had essentially rejected a similar claim in 1972, and that this was instead an issue to be left to the democratic process. And it was really that conflict in the lower courts resulting from that decision that triggered Supreme Court review. I think most people thought that the outcome in this case was largely a foregone conclusion based both on the language of the Supreme Court's decision in Windsor and based on some procedural things that had taken place in the intervening period. The Supreme Court had refused to stay decisions that invalidated state laws limiting the definition of marriage, and I think that that was really viewed broadly as a sign that the court, when the time came, would recognize such a right. And of course, Justice Kennedy, the court's so-called swing justice, has really been at the forefront of recognizing rights for gays and lesbians in cases such as Windsor and earlier in cases like Lawrence versus Texas and before that Romer versus Evans. So again, I don't think there was a great deal of doubt about the oral argument, though I think Justice Kennedy said things at the oral argument that gave both sides some degree of heart. I think the real question that really was sort of surprisingly not as much the focus was how the court was actually going to write such an opinion. And in the decision, which of course recognized such a right, the court concluded by a 5-4 vote that such a right could be found in the 14th Amendment of the Constitution, but perhaps most importantly in both of the principal components of the 14th Amendment, the Due Process Clause and the Equal Protection Clause. Now, in the opinion written by Justice Kennedy, the court rested primarily on substantive due process, this notion that the Due Process Clause, which prohibits the deprivation of life, liberty, or property without a due process of law, has a substantive component, that it guarantees certain substantive rights. And Justice Kennedy essentially said, we, the Supreme Court, have recognized a right to marry, which is unquestionably true, but in the more contentious portion of his opinion, he said that that right extends to same-sex couples and essentially says that there's no valid reason to deprive same-sex couples of access to the right to marry. Justice Kennedy also relied on the Equal Protection Clause, but I think it's fair to say that he did so very much in passing, and he did not address what is, I think, a critically important legal question, which is the degree of scrutiny that applies to laws that affect same-sex individuals. And what I mean by that is whether such laws are reviewed under a more deferential standard or whether they are subjected to the higher degree of scrutiny that, for instance, laws that treat different races differently are subjected to under the Equal Protection Clause. And that becomes an important question for a reason I will get to in a minute. Well, the majority spoke in one opinion. The four dissenters each wrote his own separate opinion. The primary dissent was written by the Chief Justice. He actually read it from the bench when the court announced its opinion, which was the first time in his 10 years on the court that he has done so. And I think it's fair to say that he felt exceptionally strongly about this case and about what he viewed as an overreach of judicial power. And his opinion, I think, really goes through the majority's legal arguments in some detail, and if you're interested in those, I would refer you to the opinion. But it really concludes with this sort of remarkable paragraph that I want to read. He says, if you are among the many Americans of whatever sexual orientation who favor expanding same-sex marriage, by all means celebrate today's decision, celebrate the achievement of a desired goal, celebrate the opportunity for a new expression of commitment to a partner, celebrate the availability of new benefits, but do not celebrate the Constitution. It had nothing to do with it. So, you know, those are some fairly strong words from the Chief Justice of the United States, I think, again, reflecting the extent to which he felt that regardless of your views on the policy question of same-sex marriage, that this really did represent an overreach. And if it was an overreach for the Chief Justice, it was definitely an overreach for Justice Scalia, who wrote a dissenting opinion that really focuses entirely on that sole issue. And I think in many ways, there's some very critical lines. He says at one point that if he had been asked to join an opinion that started with certain language, and he quotes from the majority opinion, he would have put his head in a bag. So, I mean, even by the standards of Justice Scalia, these are some fairly stern comments. But I think those comments are directed at least as much at the other members of the majority as they are at Justice Kennedy. And I think that that is because for other members of the majority, I think there's good reason to believe that if they had written the opinion, they would have been more interested in relying primarily on equal protection rather than due process. And I think in many ways the fact that this opinion is kind of a mishmash of 14th Amendment principles was really kind of what offended Justice Scalia, along with the rhetoric of the majority's opinion, which I think it is fair to say is fairly highfalutin. And so Justice Scalia wrote a very critical dissent. Justice Thomas dissented separately, as did Justice Alito. Justice Thomas focusing on what he views as the impropriety of substantive due process, and Justice Alito expressing concern about the stigmatization of opponents of same-sex marriage. I see I'm out of time, but I'm going to do what I occasionally do in court, which is to run over my red light just to say one thing, which is that I think that the legal battle is now going to move from this question of whether there is an underlying constitutional right to this very difficult question of how this newly minted constitutional right interacts with religious liberties. And there's a lot of talk about this, particularly in the dissenting opinions. My own view of the majority opinion, for what it's worth, and I'm sure we'll talk about this later, is that the majority opinion sort of leaves the court with maximum flexibility to figure out how to resolve those conflicts in future cases. But I think precisely for that reason, it's very hard to say with any certainty what the court is going to do when the inevitable cases arise where institutions or individuals exercising their deeply held religious beliefs operate in a way that creates a conflict with this newly recognized right.
Ken is absolutely right. We could spend the rest of our allotted time talking about this fascinating case and what it tells us about the court. I guess if I had one question for him or for anybody, it would be whether the Chief Justice eventually would come to regret that snarky last paragraph. I think it was very interesting that the dissenters felt so strongly that they really were willing to foul their own nest, the institutional nest being the Supreme Court, to get their points across. But anyway, I'm going to talk about the other major fascinating case of the term, which is the healthcare case, King against Burwell. And I usually don't write out what I'm going to say when I'm on a panel like this, but I am quoting from various individuals, so I actually decided to write it out so I don't misquote anybody. So we could begin our story, the story of King against Burwell, the healthcare case, at any of several points. One could be the contested passage of the Affordable Care Act in March of 2010 without a single Republican vote. Another entry point to our conversation could be the Supreme Court's decision in June of 2012, NFIB against Sebelius, which upheld the authority of Congress, you recall this case, to require individuals to have health insurance. It was a dramatic save by Chief Justice Roberts, who relied on the congressional tax authority rather than on the Commerce Clause. Or to backtrack a bit, we could begin where I am choosing to begin, and where That case, the case that 4.5 years later became the court's decision in King against Burwell, actually began with a conference at the American Enterprise Institute in December 2010, at which an employee benefits lawyer from Greenville, South Carolina, named Thomas Christina, gave a PowerPoint presentation that offered a statutory interpretation roadmap for destroying the Affordable Care Act. Mr. Christina said he had essentially stumbled upon 5 words in the 1,000-page statute in Section 36B that pointed the way. That section discussed the availability of tax credits to offset the cost of insurance purchased through an, quote, exchange established by the state, the 5 magic words. Aha. Many red states were already refusing to set up exchanges, instead defaulting to the federal government as provided for by the statute, which instructs the Department of Health and Human Services in states that fail to set up their own exchanges to set up, quote, such exchange and to run it precisely as the state exchanges would be run. So did this mean that tax credits would be unavailable in the states, the majority of the states as it turned out, where the federal government was running the exchanges? The few who understood the law back then realized that if that was the case, the statute would fail because insurance without the credits would be sufficiently expensive as to exempt many people from the individual mandate, thus opening the door to the adverse selection problem that the mandate was crafted to prevent, meaning that only sick people would bother to get insurance, bringing about the death spiral that would occur if only sick and expensive people, protected by the guarantee issue provision, actually bought health insurance. At that American Enterprise Institute conference, Michael Greve, chairman of the Competitive Enterprise Institute, had this to say about the Affordable Care Act, and here's where I'll quote him directly. Quote, "This bastard has to be killed as a matter of political hygiene. I do not care how this is done, whether it's dismembered, whether we drive a stake through its heart, whether we tar and feather it and drive it out of town, whether we strangle it. I don't care who does it, whether it's some court someplace or the United States Congress, any which way, any dollar spent on that goal is worth spending. Any brief filed toward that end is worth filing. Any speech or panel contribution to that end is of service to the United States," unquote. So, in the blink of an eye, not surprisingly, the Competitive Enterprise Institute was financing the litigation. That became King against Burwell. On the face of it, the notion that Congress would have enacted this incredibly complicated law and buried within it the seeds of its own destruction to be uncovered by a lawyer in Greenville, South Carolina months later is so preposterous that those who seized on this route to strangling the law in its cradle had to concoct a narrative that would explain such bizarre legislative behavior. The one they came up with had Congress incentivizing, quote, incentivizing the states to set up their own exchanges by threatening to penalize the citizens of those states that did not, making them ineligible for the tax credits. That tall tale was so improbable that it barely made it to the finish line. Chief Justice Roberts had this to say in his majority opinion, quote, "Contrary to petitioner's argument, Congress did not believe it was offering the states a deal they would not refuse. It expressly addressed what would happen if the state did refuse the deal, namely, the federal government would set up the identical exchanges." The plaintiffs who were recruited to bring this case almost didn't make it to the finish line either. Their claim to standing, to injury in fact, was so tenuous that conservatives of an earlier day would have laughed them out of court, but conservatives don't care about the justiciability doctrine anymore, as witnessed the fact that Abigail Fisher's lawsuit against the University of Texas is still alive and is coming back the next term. King came up through the Fourth Circuit, where a unanimous panel last summer gave Chevron deference to the Internal Revenue Service, rejecting the plaintiff's argument and holding that eligibility for the tax credit did not depend on whether the exchange was run by the state or the federal government. On the same day, the DC Circuit ruled the other way, a conflict in the circuits. But the conflict quickly disappeared when the DC Circuit decided to rehear the case en banc, setting an argument date for this past December. Nonetheless, the Supreme Court granted cert in the King case in November, a clear sign that the conservative justices, sorely disappointed that they had failed in their effort to kill the law on constitutional grounds 3 years ago, were willing and eager to take the statutory route. With the 4 votes being required for cert, and you can read my analysis of this in the program, that means that either Justice Kennedy or Chief Justice Roberts or both must have joined Justices Scalia, Thomas, and Alito in voting to grant. Yet both the Chief Justice and Justice Kennedy ended up voting for the government. What happened? It's easy to suppose that their votes represented a move for institutional, if not personal, salvation, given how flimsy the plaintiff's argument was in the clear light of day, and how the plaintiff's acontextual reading of the 5 words would have violated basic and often repeated principles of statutory interpretation, often repeated, in fact, by Justice Scalia, as the Chief Justice's opinion reminds us. We can speculate as to what happened, and that's fun to do, but we don't actually know. What we do know is that the Chief Justice wrote a very interesting and muscular opinion, rejecting the judicially modest route of Chevron deference and asserting the power to decide the question de novo. This is not a case for the IRS, the Chief said of this case, that turned on the availability of a tax credit. In his opinion, he described how the Affordable Care Act works in very accessible terms, analyzing the disputed words in light of the Act's context and structure. Quote, "A fair reading of legislation demands a fair understanding of the legislative plan," he said. Further, quote, "The statutory scheme compels us to reject petitioner's interpretation because it would destabilize the individual insurance market in any state with a federal exchange and likely create the very death spirals that Congress designed the Act to avoid." He said, "It is implausible that Congress meant the Act to operate in this manner." I won't bother, in running out of time, with Justice Scalia's ranting dissent, nor do I notice anyone accepting his invitation to rename the Affordable Care Act as SCOTUS Care. Strong majorities of Democrats, and more importantly, independents, support the decision. The Supreme Court dodged a huge institutional bullet, but why we had to go through this in the first place is a question well worth discussing. Thank you.
I want to begin by speaking my role as Dean of the Law School. I want to thank Rick Hassan for putting together this terrific program. I want to thank our staff for all their hard work. I want to thank my wonderful co-panelists for taking time from the busy schedule to be here. And most of all, I want to thank all of you for coming. We sold out at 600 attendees. We have hundreds more watching on the web, making this a very special event for the law school and the campus. I want to say a few words about the term overall, and then Rick asked me to talk about a couple of free speech cases. The Supreme Court this year decided 66 cases after briefing and oral argument. Every commentator talking about the term said that the liberal justices were more often in the majority in any of the 10 years of the Roberts Court, and maybe in any term since the end of the Warren Court. Why did this happen, and what's it likely to mean for the future? In part, it's a reflection of Anthony Kennedy's voting pattern. There were 14 5-4 decisions that were split along ideological lines, with Roberts, Scalia, Thomas, and Alito on one side, Ginsburg, Breyer, Senator Kagan on the other. Justice Kennedy is with the liberals in 9 and with the conservatives in 5. If you look at the prior 9 years of the Roberts Court, when the justices were ideologically divided 5-4, Kennedy had been with the conservatives 70% of the time, with the liberals 30% of the time. But this doesn't tell the full story. I think another part of what accounts for the decision of the term is the cohesiveness of the liberal bloc of Ginsburg, Breyer, Senator, and Kagan. For example, in the 19 5-4 decisions, they were together in 16 of them, which meant that even when they didn't get Justice Kennedy, they'd be part of a majority by attracting another justice, like Chief Justice Roberts or Justice Thomas. If you look at the 6-3 decisions, this is even more so. I would not generalize from this term that the Roberts Court is moving to the left or becoming more liberal. It's always dangerous to generalize from a single term. A year ago, everyone was focusing on the unanimity of the Roberts Court. A year ago, 66% of all the cases were decided unanimously. This year, of the cases decided after briefing and oral argument, only 34% were decided unanimously. As Rick pointed out, for next year, the court's already got on the docket affirmative action, the First Amendment rights of non-union members, redistricting and voting, is likely to have abortion cases. All areas where Justice Kennedy is much more likely to be with the conservatives than the liberals. So if this term for liberals was the return of the Jedi, next term for conservatives may well be the Empire Strikes Back. Let me talk about 2 free speech cases. The first of these is Williams-Yulee versus Florida State Bar. Florida is one of 39 states that has elected judges. Leonin Williams-Yulee ran to be elected a judge in Florida. When she declared her candidacy, she sent out a letter to supporters asking to give money for her campaign. Florida, though, like 30 other states, has a rule that says that candidates for elected judicial office cannot personally solicit or receive funds. Williams-Yulee lost her bid to be elected. Then, to add injury to that insult, the Florida bar brought disciplinary proceedings against her. They said she violated the rule that prohibited candidates for elected judicial office from personally soliciting or receiving funds. She raised a First Amendment challenge to the discipline. She lost in the Florida Supreme Court. She lost in the U.S. Supreme Court by a 5-4 decision. Chief Justice Roberts wrote the opinion for the court, joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. Notice here that even though the liberals didn't get Justice Kennedy's vote, they were in the majority by attracting Chief Justice Roberts' support. Chief Justice Roberts, in the first paragraph of his opinion, said, "Judges are not politicians, even though they're running for elected office." He acknowledged that this was a content-based restriction on speech, therefore it had to meet strict scrutiny, be narrowly tailored to achieve a compelling purpose. But he said, here the government has a compelling purpose, preserving public confidence in the judiciary. He said, if candidates for judicial office raising money undermines public confidence. He said the law is sufficiently narrowly tailored, it's not over-inclusive or under-inclusive. Justice Breyer concurred, Justice Ginsburg concurred in the judgment. They would have viewed less than strict scrutiny. They would have been even more deferential to the government. Justice Scalia wrote a very strong dissent. He went back to an opinion that he wrote in 2002, Republican Party of Minnesota versus White, where the court 5-4 declared unconstitutional a provision in the Minnesota Code of Judicial Ethics that said that candidates for elected judicial office could not make statements on disputed legal or political issues. There, the Supreme Court said that when judges run for office, they are politicians and should have the same free speech rights as others who run for office. Justice Scalia would have wanted the court to follow that here. There's an obvious tension between what the court said in White in 2002 and Chief Justice Roberts saying in 2015, judges are not politicians, even when they run for office. This is going to play itself out in the lower courts as they have to consider many other provisions of codes of judicial ethics that restrict fundraising and speech by judicial candidates. The other case that Rick asked me to talk about was Walker versus Texas Division of the Son of Confederate Veterans. In Texas, like in all states, cars have to have license plates. There's two kinds of license plates in Texas. There's general plates that are issued by the state if somebody doesn't request anything else, and there's specialized plates. And Texas allows nonprofits to have specialized plates made by the state that have whatever message they want. The Texas Division of Sons of the Confederate Veterans wanted the Confederate flag put on license plates by Texas. Texas refused, and it was sued. The Supreme Court, in a 5-4 decision, ruled in favor of the state of Texas. Here, Justice Breyer wrote the opinion for the court, joined by Justice Ginsburg, Sotomayor, Kagan, and Thomas. Once more, even though Justice Kennedy dissents, the majority is comprised of the liberal justices, joined by Justice Thomas. Justice Breyer, writing for the court, said, when the government is the speaker, its speech can't be challenged as violating the First Amendment. He said license plates are inherently the government speaking, and that therefore there can be no free speech challenge to the choice it makes for its license plates. Justice Alito writes for the 4 dissenters, and he said that the government here is really creating a forum for private speech. When the government does that, it shouldn't be able to discriminate among speakers or messages on account of viewpoint. I obviously like the result in this case, that there's not going to be the Confederate flag on the license plates issued by Texas. But I find the reasoning of the majority very troubling. The court says, it has in recent cases, if the government is the speaker, then it can't be challenged for violating the free speech clause of the First Amendment. What if a state wants to put on its license plates, abortion is murder? Or what if a state wants to put on its license plates, vote Democratic or vote Republican? Or what if a public library only wants to buy books written by conservative authors or by liberal authors? Or what if the government wants to say, we want to adopt speech that's private in a park is our speech if it's pro-war, but not if it's anti-war? I worry that this government speech doctrine is creating a loophole to the First Amendment that could lead to a great deal of restriction of speech. And that's one of the points that Justice Alito makes in his dissenting opinion.
I'll just say that without prompting, Erwin finished exactly 8 minutes. So he can talk for 2 minutes or an hour. You just tell him he can do it. I would like to ask the panel if they'd like to respond. I don't think anything controversial was said today, but in case something, if anyone would like to respond. And I'll also, while the panel is responding, I'll invite anyone who has a question. There's a microphone here in the front, and there's one about halfway down on that side, if you have a question. And also I have some questions that have been coming in through Twitter. So I don't know if anyone would like to respond today.
I'll underscore what Erwin said about not mistaking this term for a turn to the liberal by the Supreme Court on a couple of counts, and the one I'll just mention very briefly is when the court affirms a ruling by a lower court that basically maintains the status quo, when it's a conservative court and conservative petitioners bring that case up and ask the court to overturn it. King against Burwell is a perfect example. The court failing to drive itself off a cliff and going that route does not mean that it's a liberal court. It means that it's a court that's not as conservative as its allies out in the world would hope and like it to be. And I think we have to keep this in mind when we look at the term that is forming for the upcoming first Monday in October. For instance, on religious accommodation cases that are reaching the court now in the wake of the Hobby Lobby case from last year, where these various religious groups are saying, instead of saying thank you to the Obama administration for accommodating our religious needs in offering us the opt-out from the contraception mandate, we don't even have to file the form. All we have to do is write a letter to the Department of Health and Human Services saying we choose to turn over this obligation to our private third-party insurer, but that's not good enough. That makes us complicit. Every one of the 4 federal appellate circuits that have dealt with this issue so far have said that's not right. You don't have such a claim. And if the Supreme Court should take that case and affirm that, it doesn't mean it's a liberal court. It means it's not a court that's going to drive its First Amendment religion doctrine off a cliff.
Maybe just a couple of thoughts. Whenever I hear people speculating about whether a particular year of Supreme Court work represents a turn to the left or the right, I'm always reminded, perhaps because I'm of Indian descent, of the old Indian fable about the blind men and the elephant, where the various blind men feel various parts of the elephant, and depending on what part they feel, they conclude that it's a different object. And so, I kind of leave it to all of you to figure out which part of the elephant we're talking about this year. But the Supreme Court really is an elephant, and it's very hard to draw judgments based on a single year of work. I just want to say a quick thing about King and a quick thing about Glossop. First, about Glossop, the death penalty case. Boy, I've been listening to Supreme Court oral arguments since I was a law clerk now 15 years ago, and I can't remember an argument as heated as the oral argument in Glossop, and I think it's fair to say that the justices really violated both of Rick's rules in their questioning. They made a number of statements that were neither brief nor questions during that oral argument, yes. so much so that the Chief Justice told one of the lawyers, we're going to give you more time yes. because we've taken up even more of your time than usual. And that was borne out in the opinions. I mean, so much ink has been spilled about Obergefell and King versus Burwell, understandably, but boy, when you talk about heated opinions, mm-hmm. I think those opinions in Glossop are about as heated as you ever get. I do think that the outcome in that case was largely controlled by a prior Supreme Court decision, a decision in a case called Bays versus Reese, which really grappled with this question of whether prisoners have to identify alternative methods of execution so as to differentiate their claims from challenges to the death penalty outright. But the court nevertheless took this case and essentially reaffirmed the rule of Bayes in its decision. As to King versus Burwell, just to say a little bit in response to Linda's characterization of the case, look, the provision that was at issue in King versus Burwell was not some random provision of this 1,000-page law. It was the provision that provided tax subsidies, and it could not have been clearer in stating that subsidies were available only to individuals who purchased insurance on exchanges established by the state. And so, one might think that it is somewhat atextual to conclude that where an individual purchases insurance on an exchange established by the federal government, which last time I checked was not a state, that they would not be entitled to subsidy, or that they would nevertheless be entitled to subsidies. And look, I think the problem for the challengers in this case was not so much the text of the statute. It was that they were really unable to point to any member of Congress who at the time expressed the view that Congress was in fact drawing this distinction, that it made sense to provide subsidies only to individuals who purchase insurance on state-established exchanges and not individuals who purchase insurance on federally established exchange. And I think you can devise a policy justification for that, but there was really no evidence that Congress thought that at the time. Now, there was really no evidence that anyone in Congress actually read the law until it was enacted. As Nancy Pelosi said, we have to pass it in order to find out what's in it. It may very well be that this guy in Greenville, South Carolina was the first person who actually sat down and read the entire thing, which is not something I would wish on to my worst enemy. But in any event, I think that that is what was really going on in the case. And I think that what actually set off Justice Scalia so much in the dissenting opinion was that the court really did not apply Justice Scalia's approach to statutory interpretation at all. And of course, if there's anything that Justice Scalia feels strongly about, it's how the court should go about interpreting statutes. Justice Scalia's view is that the text really does control, and that in many ways that is a disciplining mechanism for Congress, because if Congress is held to what it says in statutes, it will know that it has to draft statutes with care, and that if it does not do so, it will have to amend the text of the statute. Now, the court could have said in the opinion, well, look, the statute says exchanges established by the state, but there is an exception, even in Justice Scalia's view of statutory interpretation, where an interpretation would be absurd. But instead, the court said, well, we're just going to look to context. And what that context seemed to essentially consist of was the conclusion that this could not have been what Congress actually meant. And in an opinion written by the Chief Justice, I think that that opinion really reflects the fact that Justice Scalia's view of statutory interpretation does not command a majority of the current court. And even among the so-called conservative members of the court, there are those who are willing to look beyond statutory text to legislative history and considerations of policy. And I think that that's frankly what set off Justice Scalia in his dissenting opinion.
We have time. So I have two quick comments about Glossip and then one question. So the comments relate to, yes, the oral arguments in this case were incredibly testy, but the one thing I wanted to mention about Scalia's opinion is it gives credence to a recent article written by Rick Hasson about the Supreme Court declaring Justice Scalia as the most sarcastic judge. And I wanted to just share that the last line of Justice Scalia's dissenting opinion in Glossip was, not only does Justice Breyer reject the death penalty, but he also rejects the Enlightenment. And then just in terms of the second point of Glossip, where I think Cannon said that it was largely based on a prior decision, the Bayes decision, and I just wanted to respond briefly to that because the Bayes decision is somewhat related to the holding in Glossip, and we're talking about the holding that inmates have to allege that there's an alternative method to execute them. I think there is some basis for argument that that holding is based in the Bayes decision, but what I want to say is what Justice Sotomayor wrote in her dissent, which was the implication of finding that, what that means is, and it can't mean this, the Eighth Amendment, what it means is the states could decide that they wanted to draw and quarter people, or torture them for hours, or actually burn them at the stake, she writes. And that would be fine under the Eighth Amendment if inmates did not come up with a viable and less painful alternative. And Sotomayor says that can't be right. And I agree that that is the implication of the decision, but Justice Alito writes back and he says, you know what, that is just outlandish rhetoric and simply not the case. So anyway, I want to respond to Bays, but then the question I have for people is I'm very curious about what people think will happen next term in the Fisher case. So Fisher, they granted cert again in Fisher. Fisher is coming back. Kennedy is likely to be an important vote here, and I'm very curious about people's thoughts on Kennedy's role and what you think will happen.
You don't need to answer that question.
Yeah,
That's a nice easy one.
yeah. I'm not in a position to predict outcomes as a sitting Court of Appeals judge, but I mean, I would pick up on Linda's point that it doesn't always follow from a cert grant. Even 4 or 5 people that want cert granted doesn't mean that's how they're going to vote when the case gets up to the court. And in fact, you could argue that something similar may have happened last time the case was at the court. So the thing I was going to say, everyone's hesitated to draw too many conclusions about winners and losers at the court, and shockingly, I'm going to not hesitate and say there was a winner. I'm quite skeptical, as the others are, saying liberals won or conservatives won, or this is a liberal court or this is a conservative court. This interest group or that interest group benefited more than the other. But I would say there is a victor, and I would say it's more over time, but definitely this term was emblematic. And the way to think about this, in my view, is not to look at interest groups, which come and go, but to look at the branches of government: the court, Congress, the president, and the states. Those are the 4 key institutions. We're represented in different ways, people through all of them. And I would say the clear winner is the court in terms of power. In terms of who has power among those 4, power is often zero-sum. There's one winner and one loser. And I would say both this term and in general, the trend, we've had a so-called conservative court, a majority of Republican-appointed justice for quite a long time. In the 80s, the whole idea was to get the federal courts out of the business of making the key policy calls in the country. And I would say that most definitely has not happened, and if anything, it's going the other direction. I think this term really indicates that. Whatever you think about Obergefell, you can't deny that the court is the one that has made that decision. Even King versus Burwell, which you might say is a case where the court stepped back from controlling it, think about these 2 things. The way that case was perceived in the country, whether by lawyers or non-lawyers, was effectively another decision by the court about whether this law was going to be good. That's really how it was perceived. And then when you think about their mode of analysis, the most modest approach to take, Linda mentioned this briefly, was to invoke this doctrine, Chevron deference. We won't ruin the presentation by talking too much about it. But it does have this, it has this really critical feature which you need to understand. It does 2 things. What Chevron deference means is when there's ambiguity in something Congress passes, we assume Congress meant to delegate the gap filling to an agency. All right, and the agencies are appointed by the president, so that's executive branch. But it does something else. It says that we're going to assume that the agency gets to resolve what the statute means as long as it's a reasonable interpretation. That second point, in Chevron's a 1984 case or so, really took a lot of power away from the court. Most foreign countries, when you talk to judges in foreign countries, they're like, what were you thinking? You guys are the ones that created Marbury. You're the ones that say it's the court's job to say what the law is. And ever since Chevron, the federal courts have given that power to non-elected, often non-lawyer executive branch agencies. King versus Burwell does not mention Chevron at all. I think we have a court where there's more than a majority of justices that are increasingly skeptical of it. And none of this is a value judgment, but that is taking power back. So the 2 biggest cases of the term were an accretion of power in the direction of the federal courts. And if you ask me, that's something that's happened more and more over time. And again, it's not a value judgment. I would make the point, I think the American people seem to like it. I think if you put in front of most interest groups and most Americans this choice, pick your the 5 cases of the U.S. Supreme Court you like the least. Okay, now let someone who thinks differently about politics and get them to pick the ones they like the least. Would you do that trade? So what ends up happening is each of you pick 5, the ones you hate the most on the other side, but then, sadly, the other person gets to do the same. Would you take that trade? And I don't think the American people would take that trade. I think they like a court that's doing this. They realize they win some, they lose some, and it's just where American government is. But it is amazing to me, because you wouldn't have thought this is how it would turn out.
Erwin?
I just want to make 2 quick comments. I also wanted to speak to the language in Justice Scalia's concurring and dissenting opinions, though I want to make a different point. We all know that Justice Scalia has often used sarcasm, but I think this year the level of personal attack and invective is unlike anything I've ever seen in Supreme Court opinions. And I want to suggest that it's a terrible message for law students and for lawyers about how to write. And law students read it, they're amused by it, and they try to emulate it. I know it's amusing to many people, but it has no role in judicial opinions, and I think that we as a profession need to come out and say that loudly. As law professors, what we try to do is teach students how to construct arguments, how to respond to arguments by identifying logical fallacies, by constructing counter-arguments. We don't accept insult and personal attack as a substitute for that. In fact, if a lawyer put in a brief some of the things that Justice Scalia put in his opinions, that lawyer could be and should be sanctioned. It's less, not more acceptable when it comes from a Supreme Court justice. I want to make a second point. The second point, if it's okay, Rick, I want to make was to respond to Linda's question. Will Chief Justice Roberts regret that last paragraph where he said the majority's decision finding right to marriage equality isn't constitutional law at all? I think he will. I think he will in part because he's dissenting from a decision that we regarded by history, like Brown versus Board of Education, as expanding equality and liberty. I think also because he's just wrong when he says it's not constitutional law. I mean, think about it this way. There's no doubt there was a constitutional issue presented to the Supreme Court. Gay and lesbian couples cannot marry, whereas opposite couples can. That's the basis for an equal protection claim. In fact, I think there's a sex discrimination claim. The only reason I can't marry a man in a state that prohibits same-sex marriage is because of my sex. And the Supreme Court has said for decades that the right to marry is a fundamental right. Now, that doesn't say the laws are unconstitutional. It says there is a constitutional issue that the court had to resolve. Now, if it's a fundamental right involved, the government has to meet strict scrutiny. But even under the most basic form of review, if the government is discriminating, there has to be a legitimate interest. And what legitimate government interest is served by preventing same-sex couples from marrying? I think the argument the states really wanted to make is they could make a moral judgment that homosexuality was wrong. But the Supreme Court in Lawrence versus Texas said states can't make that judgment. It's not a legitimate interest. So what states primarily relied on was saying there's a long history of marriage being between opposite couples. But a history of discrimination never is enough to justify current discrimination. There has to be something else besides the history of discrimination. So the primary argument the states made to the Supreme Court was that marriage is primarily about procreation, and only opposite couples can procreate without artificial assistance. Well, no state has ever limited the ability to marry to those who have the desire or the ability to procreate. More importantly, same-sex couples will procreate through adoption, artificial insemination, surrogacy, whether or not they're able to marry. And as Justice Kennedy said, there's hundreds of thousands of children of same-sex couples. Shouldn't they be able to have the benefit of having married parents? So, Lynn, in answer to your question, I think he'll regret it because it was a question of constitutional law, and I think history will regard it as the clearly right answer, just in terms of constitutional law.
Give Linda quick response, and then I do want to get to some questions. So.
Okay, just very quickly, in response to Judge Sutton's very interesting comments about Chevron, for the non-lawyers in the audience, you probably never heard of Chevron. It's one of the most, if not the most, commonly cited Supreme Court decisions of the last 100 years or so. The court came up with it. It was an opinion by Justice Stevens in the early 1980s when the White House, it was the Reagan White House and a Democratic-controlled Congress. And so what you want to do is you want to uphold the right of the executive branch to make its rules. Now, we have a Democrat in the White House, and maybe for a long time from the point of view of certain Republicans. We Republican-controlled Congress, and funny thing, Chevron's not so popular anymore at the Supreme Court. So I would just say sort of watch that space. Very quick answer to the question of Justice Kennedy in the New Fisher case. So what we don't know, it takes 4 votes, the votes of 4 justices to agree to hear a case. We don't know whether Justice Kennedy was a 4th or 5th vote. Another way of looking at it is perhaps the 4 were so angry at him, the 4 to his right, were so angry at him for failing to hit the home run that was expected the last time the Fisher case was up, that they may have voted to grant to really put the heat on him. But he certainly is the justice on the spot, that's for sure.
All right, we have a little less than 15 minutes, and we're going to go to questions. Go ahead.
Thank you.
Is that-
It's not on.
Someone's coming to turn it on. Go ahead.
I've never needed a mic. The discussion of the comments by Justice Roberts about the constitutionality of the opinion in same-sex marriage. Well, I believe Justice Roberts supported Citizens United. And there certainly is a lot of debate and discussion about the constitutionality of that decision. Who, if anyone, tracks the double standards that exist in the opinions from the Supreme Court when in one case they're willing to claim the Constitution has entitled them to something, and in another case they feel comfortable suggesting the Constitution has nothing to do with something. Thank you.
Does anyone want to respond to that question? You sure?
Sure. When the majority of the court strikes down a law, the dissent frequently, if not always, says that this was usurping the democratic process and argues for deference to the political process. So Chief Justice Roberts, in his dissent in the marriage equality case, says this is usurping the democratic process. We should have left this to the democratic process. Now, of course, Chief Justice Roberts was also part of the majority in Citizens United that struck down a key provision of the McCain-Feingold bipartisan campaign finance act. He was a key part of the majority 2 years ago in striking down a key provision of the Voting Rights Act of 1965. So both liberals and conservatives sometimes want to defer to the government, and both liberals and conservatives sometimes want to overrule the government. It's just a question of when. Cannon mentions affirmative action. Here, the conservatives on the court are likely to want to strike down what the state of Texas did through its Board of Regents. The liberals are going to defer to what the Board of Regents did. Both sides sometimes want to defer, sometimes want to overrule. It's just the question of when that divides them.
I would add it's a question for the citizenry. How many of you are consistent in what you want the court to do? I mean, how many of you say across the board I'd prefer judges that defer, or across the board I'd like judges who interpret in a muscular way? I'm here. Let me know. I mean, you tell me. I'll go one way or the other. I'll be very muscular across all rights, including rights you don't like, or I'll be very deferential, whether you like the rights or not. I think it's not just a problem for judges. I think it's a problem for we Americans.
I've been getting a number of questions on Twitter about term limits for Supreme Court justices, based in part on Irwin and many others have called for 18-year term limits, or other variations on this. Ted Cruz and Irwin agree on something, I think. And also questions about court transparency. And so I don't know if anyone on the panel, Irwin's on record for the term limits. I don't know if anyone on the panel has thoughts on these questions.
I mean, I'll tackle the second, since at least as matters stand, the Constitution does guarantee judges life tenure during periods of good behavior. On the question of transparency, I mean, look, I think that the Supreme Court is becoming more transparent, which may not be saying very much. There was a time when you couldn't even get the transcripts of Supreme Court oral arguments until the year after, whereas now, if you're a law geek like me, every Friday afternoon you can at least download the audio of Supreme Court oral arguments so that you can have a very boring soundtrack to your afternoon workout. And so, I think, yes, one could argue that they should have at a minimum, audio in real time, or heaven forbid, even cameras in the courtroom. I don't know that there's much of an argument that the court should be more transparent in terms of its decision-making, because after all, judicial deliberation is traditionally done in private, and I think that that makes the process operate somewhat more efficiently. I do think that one thing that has happened is that we are seeing a lot more of the justices than we used to, and thanks to innovations like YouTube, when a justice gives a speech in some remote place. In the old days, Linda, when she was covering the court, would have to trek out there if anyone wanted to know what the justices said. Nowadays, whenever a justice gives a speech, pretty much everywhere, at pretty much anywhere, we know what the justice has said, and I think we have a better sense of how the court operates as a result of the justices being a little bit more in the public eye.
Yes.
So in Obergefell, I'm thrilled with the outcome, and I think the equal protection rationale that Professor Chemerinsky articulated is exactly right. But I share some of Justice Scalia's confusion about Justice Kennedy's understanding or interpretation of substantive due process and how cases are to be decided under the Due Process Clause. And so I'm curious about how this court sees the future of, or how this panel sees the future of substantive due process on this court, particularly while Justice Kennedy remains the swing vote.
That is such an interesting question, because there's this huge debate going on now on the libertarian right about what to make of the Chief Justice's dissent, which basically was saying, look, you're trying to bring back Lochner, substantive due process in the Lochner era, and that's totally the wrong way to go. Of course, he is of the generation, as maybe we all are, who came up through their education learning that the court's decision back in Lochner was one of the worst things that the Supreme Court ever did. But there's a whole discussion going on about, it's time to bring back Lochner to protect economic rights and so on. And there was a decision the other day out of the state Supreme Court, I think in Texas, that struck down a licensing requirement for a certain kind of cosmetic treatment, invoking basically a Lochnerian view, and this is being cheered. And the Chief Justice, poor Chief Justice can't win. So, he makes no friends on the right by upholding the Affordable Care Act, and he also makes no friends on the right for dissenting in the marriage case because he dissented on the wrong grounds. But this whole debate over the future of substantive due process is a very rich one and is unfolding before us in real time.
And I would just add one quick thought, which is that, of course, the most noteworthy and certainly the most obvious recent case in which the court relied on substantive due process was Roe versus Wade, which is not cited, I think, anywhere in any of the opinions in Obergefell.
Oh yeah, in his dissent.
Well, I don't. If he does, he focuses primarily on Lochner, certainly, and I do think that a lot of his reasoning with regard to Lochner, Linda's going to prove me wrong, not for the first time, could be directed to Roe versus Wade as well. And I think that the court's reliance on substantive due process is interesting precisely because, of course, there's this great debate in the world at large about whether the right that was recognized in Roe versus Wade should instead have rested on equal protection. Justice Ginsburg had given speeches sort of indicating that that would be a better rationale for Roe versus Wade, and yet you have this opinion in this case which relies primarily on substantive due process and not the equal protection type rationale that Irwin had set out. And so I think that that is kind of lurking in the background here, and it's particularly noteworthy because, as was pointed out, I think there's a very good chance that the court is going to have at least one, if not more, abortion cases on its docket next year.
I think in the dissent he referred to a thoughtful commentator who wrote about a case, and he didn't name the thoughtful commentator, it was Ginsburg, and the case's name was Roe versus Wade.
Yes, I think that's right. So.
We have time for one last
Thank you.
question.
Thank you. I just wanted to follow up with a point that was made earlier. With regard to Hodges, how do you anticipate sort of there being a balance of First Amendment religious freedom with the outcome of that case? And then additionally, would it have been relevant or potentially easier to enforce, granting these marriage licenses had the decision, in Kennedy's majority opinion, been decided under equal protection as opposed to due process?
Well, I think it's an interesting question whether if, say, the court had accepted the views of the Solicitor General, and the Solicitor General on behalf of the United States argued to the court in essence that it should rest on equal protection and apply heightened scrutiny, and so in other words to treat gays and lesbians like other groups that have been accorded higher scrutiny under the Equal Protection Clause. And I think it's an interesting question whether that might have affected the way that the court would think about this balance with religious liberties, and whether that was motivating the court or at least Justice Kennedy, in not relying more explicitly on equal protection. I think the thing that I find hard to get my hands around with regard to these religious liberties cases is just kind of the full set of factual permutations in which these cases could arise. So on the one hand, you have cases like the case from New Mexico, the Elaine photography case, where you had, I think, a wedding photographer who refused to perform, to take photographs at a same-sex wedding, and there was a claim that that violated state law, and then that in turn triggers federal constitutional questions. On the other hand, you have all these questions concerning religiously affiliated institutions that want to deny housing to same-sex couples, or that might simply want to preserve their federal tax-exempt status, and whether the court would draw distinctions between those various factual permutations, who knows? I think the court's opinion really does not provide a lot of guidance.
Let me just, since we have a minute, let me just turn the question back to you that you asked about Fisher. Do you have a prediction about
Oh,
what's
that's
going on?
not fair.
Well, usually if you ask the question, you must have been thinking something.
Well, I was just curious because Justice Kagan will likely recuse herself again, right?
She already has,
from the
I believe.
case. Oh, I missed that. Yeah, and so I think that I'm just going to not repeat, but sign on to what Linda said earlier about the importance of Kennedy to this, and just a speculation about why the case is before the court again now. And so I'll leave it at that.
Of course, back to the question of court transparency. Of course, if the court were to become so transparent as to tell us who votes to grant cert, that would certainly be a new day in understanding the Supreme Court.
I will say just one sort of factual point on this score. I happen to be on the website of the Supreme Court of England and Wales. Don't ask me why. And interestingly, that court, because I'd run out of things to listen to when I was working out. I noticed that, interestingly, when they deny review, they actually give reasons. And so they issue an order list where they have like 2 or 3 sentences that say, this case is not very important, or this case does not present a substantial issue. Just imagine how much time that would take for our Supreme Court with 7,000 cases a year if they had to give a reason whenever they decided to grant or deny review.
Yeah, I know I'd settle for knowing about who's voting for the grants. We can start there. All right, I want to thank all of you for attending, and if you could just join me in thanking the panel for giving their time today. We'll see you next year for the 6th annual Term in Review event.